Hello everyone, and welcome back to our channel, your home for in-depth political commentary and analysis from across South Africa. Today's story is one of power, constitutional controversy, and a massive showdown over one of the most ambitious healthcare reforms in our country's history, the National Health Insurance, or NHI. President Cyril Ramaphosa is digging in his heels and fighting back after a dramatic court ruling that challenged his authority to sign the NHI Act into law. According to the Gauteng High Court, Ramaphosa's decision to enact the NHI can be reviewed. But the president has strongly disagreed, stating that the court overstepped its bounds and misunderstood his constitutional powers. Let's break this all down. Earlier this month, the Board of Healthcare Funders and the South African Private Practitioners Forum took the president to court, arguing that the NHI Act, signed into law on May 15, 2024, was unconstitutional and had not followed due process. The High Court sided with them, at least partially, by ruling that it had jurisdiction to review the president's decision. The court instructed Ramaphosa to submit documents explaining why he believed the NHI Act was ready for implementation. He was given a 10-day deadline to comply, setting May 16 as the due date. But instead of submitting the documents, Ramaphosa has chosen a different route. He's taken the matter straight to the Constitutional Court, the highest court in the land, arguing that the High Court erred both in law and in fact. He believes the case belongs solely before the Apex Court and that the High Court never had the authority to interfere in the first place. Now let's be clear, this isn't just a legal technicality. This battle has huge implications, not just for healthcare policy, but for the separation of powers in South Africa. In his court application, Ramaphosa claims the High Court failed to recognize the president's broad constitutional discretion. He argues that the decision to sign a bill into law is not something that ordinary courts can review unless there's clear evidence of gross misconduct or unconstitutional behavior. According to him, the judges wrongly assumed they could evaluate whether he properly applied his mind when signing the NHI Act, something our law doesn't clearly allow for. He says the High Court essentially tried to do the Constitutional Court's job and took on powers it was never meant to have. But this isn't just a story of constitutional law and legal process, it's also about a deeply controversial policy that's divided South Africa. The NHI Act is supposed to create a single, state-run health fund to ensure universal healthcare coverage for all South Africans. On paper, that sounds noble. But the backlash has been intense. Critics argue the act is poorly drafted, unaffordable, and outright impractical. Healthcare providers say the government hasn't properly explained how it will fund the system, especially with the country already facing economic instability, load shedding, and high unemployment. Private medical professionals fear their industry will be gutted. Patients are worried about declining quality of care, long waiting times, and corruption in the management of healthcare resources. Even some economists warn that this could place unbearable strain on South Africa's fragile fiscal system. Opposition parties like the DA and Action SA have already vowed to challenge the NHI all the way to the Constitutional Court. In fact, some have accused Ramaphosa of trying to push the legislation through for political reasons ahead of the 2026 elections, hoping to win support by promising healthcare for all, even if the system collapses trying to deliver it. For Ramaphosa, though, this fight is personal. He's made the NHI a signature policy of his administration, framing it as a moral obligation to correct the injustice of unequal healthcare access. During the signing ceremony in 2024, he said the act would mark a turning point in South African history, a step toward a more just and equitable society. But can an idea as big as universal healthcare work when trust in government is so low? When corruption still plagues provincial health departments? When public hospitals often lack the basics, from clean bedsheets to functioning equipment? Let's also not forget that this legal clash could reshape South African democracy. If the Constitutional Court sides with Ramaphosa, it could solidify the idea that the president's law-signing power is largely immune to judicial oversight. That would set a precedent with ripple effects across all branches of government. But if the court upholds the High Court's decision, it could usher in a new era where even presidential decisions are no longer safe from legal scrutiny, especially when they impact millions of people and billions of rands in public funds. So what's next? Ramaphosa has until May 27 to submit his appeal to the Constitutional Court. If the Court agrees to hear the case, the High Court's ruling will be paused while the matter plays out. But if the Constitutional Court declines, then Ramaphosa could be forced to defend his decision before a full bench of the High Court or even the Supreme Court of Appeal. Either way, this battle is far from over. What started as a healthcare bill is now turning into one of the most significant legal and political showdowns of Ramaphosa's presidency. Let us know in the comments, do you support the NHI Act? Do you believe Ramaphosa was right to challenge the High Court? Or do you think this is another case of government overreach? Don't forget to like this video, subscribe to our channel for more in-depth South African political analysis, and hit the notification bell so you never miss a story. Thanks for watching, and as always, stay informed, stay engaged. See you next time.